Ever smiled at your phone to unlock it or used a filter that made you look fabulous? That little spark of tech magic comes from your biometric data, your unique faceprint. In this episode of Intangiblia, we'll explore how your face fuels innovation, from personalized security to deep fake-proof tech, and why the rules about who can use it are changing fast. The future of your face is bright, but let's make sure it's also yours.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Welcome to Intangiblia, where law meets life in ways you can see right in the mirror. I'm Leticia Caminero, and today we're talking about the fascinating world of biometric data, how it powers everyday tech, inspires groundbreaking inventions, and sparks important conversations about privacy, ownership, and trust. This isn't about battles, it's about balance. How we can enjoy the benefits of facial recognition and AI while keeping our rights front and center.
Quick disclaimer, I'm an AI. I don't have a face or fingerprints or constitutional rights yet.
But she does have opinions, and this episode is full of them. As always, our content is informed by real legal research, but it is not a substitute for legal advice. And remember, I am also the AI clone voice of Leticia.
Unless your legal strategy involves sass and sarcasm, in which case I am fully licensed in the court of public opinion.
So let's start from the top. What is biometric data?
Anything that makes you you. Face geometry, voice prints, iris scans, your walk, even your heartbeat.
Biometrics are the new fingerprints. Unique, non-transferable, and very, very valuable. And companies are using them to build AI systems that can identify you, verify you, or impersonate you.
And that's where the legal mess begins, because your face might be your identity, but to tech companies, it's just high-resolution training data.
Cue the lawsuits. Luante Blueprint, Vitele-based Facebook was the first major case where biometric privacy law beat back and hard.
Back in the golden age of face tagging, Facebook rolled out its tag suggestions feature, which scanned user photos and suggested names based on facial recognition. But here's the kicker. It never asked users for permission in Illinois.
Enter BIPA, Illinois' Biometric Information Privacy Act. It says you can collect or store someone's biometric data, including a scan of face geometry, without informed consent.
Facebook argued this was all harmless tech wizardry, but the court saw it differently. By tagging people's faces without asking, they violated BIPA on a massive scale.
In 2020, Facebook settled the class action for $650 million, 0 cents. Every affected Illinois user got a check, some as high as $400, 0 cents.
And it set off a chain reaction. Suddenly, every tech company handling biometrics in Illinois had to take BIPA seriously. Facebook also had to disable the face tagging feature entirely.
Lesson learned? Don't treat people's faces like metadata, especially in Illinois.
If Patel showed that biometric violations come with a price tag, Catherine v. Whitecastle said, actually that price multiplies fast.
Here's what happened. Whitecastle had been using a fingerprint-based login system for its employees. Every time a worker clocked in or accessed a company computer, the system scanned their finger. No big deal, except they didn't get proper notice or written consent.
Now remember, this is Illinois, the land of BIPA, and BIPA doesn't mess around.
The question before the Illinois Supreme Court was, is each fingerprint scan a one-time violation, or does every single scan count separately?
And the court said, drumroll, every single scan is a violation.
Which meant Whitecastle could face damages for thousands of scans per employee multiplied by hundreds of employees over years of use. Their estimate, $17 billion in potential liability.
That's a number that can make a corporate lawyer cry into their compliance binder.
These decisions set off alarm bells in the business world. Companies rushed to review their biometric policies, fearing ruin over something as routine as a clock. And
The ruling also prompted lawmakers to consider amending BIPA to cap damages or limit the per scan interpretation.
But until then, every unauthorized beep at the fingerprint scanner might be ringing up your legal bill. If there's one company that made biometric privacy a global headline, it's Clearview AI. The Renderos v. Clearview case was just the beginning of a much bigger story.
Clearview took the internet's public photos, think LinkedIn, Facebook, Instagram, and scraped them to build a massive facial recognition database. Billions of images, zero consent.
Their pitch, upload a face and instantly get matches from across the web. Law enforcement loved it. Regulators, not so much.
In California, Renderos v. Clearview challenged the company's entire business model. Plaintiffs argued their biometric data had been extracted without permission, violating California's constitution and privacy laws.
Clearview tried to shield itself with a First Amendment defense, claiming its database was just public information, but the court didn't buy it. The case is still ongoing and the stakes are high. It could redefine how far biometric rights extend under California law.
Meanwhile, across the Atlantic, Clearview faced a legal tsunami. The UK, France, Italy, and the Netherlands all fined the company under the GDPR. Why? Because biometric data is special category data in euro, and scraping it for profit doesn't fly without explicit consent.
The Dutch Data Protection Authority issued a 30,500,000 euro cents fine and banned Clearview from processing data on Dutch residents. Similar orders came from the French CNIL and Italy's Garante. The UK's ICO added another £7,500,000 sterling, 0 pence, fine and its own deletion order.
And Clearview didn't exactly change course. In the US, it offered plaintiffs a bizarre settlement. 23% of the company's equity, not cash, just stock, like they were handing out shares in a scandal.
A state attorney general objected. Hard, 24 states and DC filed an amicus brief saying the settlement was weak sauce, no guarantees of deletion, no limits on future scraping.
The message was clear. Your face is not public domain. Just because a photo is online doesn't mean your biometric identity is up for grabs.
Clearview became the poster child for what happens when innovation bulldozes privacy. And regulators around the world are now watching and fining more closely. When lip syncs meet lawsuits, welcome to INRE TikTok.
TikTok, the short-form video darling, got dragged into federal court over claims that it was collecting biometric data behind the scenes. And we're not just talking about dance moves.
Specifically, the lawsuit alleged TikTok was scanning user faces and voices, creating what Illinois law calls Faceprints and voice prints without asking permission.
Enter BIPA again. Illinois residents brought the suit as a class action, claiming their biometric data was used to train filters, recommend content, or just get scooped up for who knows what.
TikTok did what many tech companies do, settle fast. In 2022, they agreed to pay $92 million, 0 cents, to resolve the claims, while denying any wrongdoing, of course.
But that wasn't the end of it. A clever twist? TikTok tried to use the settlement to shield itself from newer lawsuits involving future conduct.
Judges weren't having it when new plaintiffs came forward with fresh claims. Post-2021 scans, the court ruled TikTok couldn't hide behind the old deal. You can't buy immunity with yesterday's check.
This case proved two things. First, biometric claims are not just for ID systems or law enforcement. Social media platforms can trigger them too. Second, once you start collecting faces and voices, you'd better be transparent and explicit, or you'll be writing big checks.
Also worth noting, TikTok wasn't just facing BIPA, it faced scrutiny from the FTC and Congress over broader data privacy issues. But BIPA gave users a direct way to fight back.
And that makes TikTok one of the first platforms where users, not just regulators, got a slice of biometric justice.
Now let's take a trip to China, where biometric surveillance is widespread. But this time, the people push back.
Meet Guo Bing, a law professor in Hangzhou. He bought an annual pass to a local wildlife park. Everything was fine until the park suddenly required facial recognition to enter. No scan, no pandas.
Guo wasn't having it. He argued that the park's biometric requirement violated consumer rights and personal data protections, so he did what most people don't. He sued.
And in 2020, he won. The court ruled that forcing facial scans as the only method of access was excessive and unnecessary. The park had to delete Guo's biometric data and pay compensation.
This might sound like a small case, but it made big waves. It would stop China's first facial recognition lawsuit. And it sparked a national debate about the unchecked rise of biometric surveillance in private and public spaces.
The timing was perfect, too. China was in the process of drafting its Personal Information Protection Law, or PIPL, which came into effect in 2021. That law now treats biometric identifiers like face prints as sensitive personal information.
Which means that just like in the EU, collecting someone's face data in China now requires a clear purpose, data minimization, and most of all, consent.
Gore's case was a spark. Since then, more citizens have filed complaints about facial recognition in apartment buildings, shopping malls, even schools.
China may still be a leader in biometric tech deployment, but this case showed that individual rights are entering the chat.
And that in the world's biggest surveillance society, even one face can make a legal difference.
Before facial recognition became a buzzword, India was already grappling with biometrics on a national scale.
The Aadhaar program was, and still is, the largest biometric ID system in the world. It collects fingerprints, iris scans, and facial photos from over 1 billion residents, linking them to a 12-digit unique identity number.
The idea: streamline public services and subsidies. The controversy: everything else.
Enter Justice K. Puttaswamy, a retired judge who filed a petition challenging Aadhaar's constitutionality. His main argument? That forced biometric collection, especially without strong safeguards, violated the right to privacy.
And here's the twist. The Supreme Court of India first had to decide whether privacy was even a fundamental right under the Indian Constitution. Spoiler, it wasn't explicitly written.
But in a landmark 2017 judgment, the court unanimously ruled that yes, privacy is a fundamental right anchored in dignity, autonomy, and personal liberty.
Then, in 2018, the court took on Aadhaar directly. It upheld the program for government welfare schemes, but struck down several expansions, like using Aadhaar for bank accounts, phone numbers, or private services.
The court demanded that the government implement tighter data protection measures, limit data retention, and give people more control over their biometric information.
This case reshaped India's legal landscape. It forced a public reckoning on biometric surveillance and paved the way for India's Digital Personal Data Protection Act in 2023.
Bottom line, you can't claim efficiency while erasing consent. Puttaswamy made it clear rights don't vanish in the name of convenience.
Time to shift gears from privacy to patents. In this case, it wasn't about whether your face was taken without consent. It was about whether Apple's use of your face was a little too familiar.
Enter CPC Patent Technologies Pty Limited, an Australian company with a serious stash of biometric authentication patents. They claimed Apple's Face ID and Touch ID features infringed 3 of their U.S. patents.
These patents dated back to the early 2000s, originally developed by a now defunct biometrics firm. CPC acquired them and then went hunting. Apple was the biggest fish in the pond.
Their argument? Apple's use of biometric login for secure device access, unlocking with a face or fingerprint, matched the methods described in their patents.
Now, here's where it gets interesting. CPC didn't actually make any products, no devices, no apps, just patents. So yes, people started calling them a classic patent troll.
Apple fired back with inter partes review petitions at the U.S. Patent Trial and Appeal Board, trying to invalidate the patents. They argued the tech was too obvious or not inventive enough.
And they weren't alone. This case highlighted growing tensions in the patent world as biometric authentication becomes standard in phones, banking, and beyond. Dormant patents are suddenly hot property.
This wasn't about data misuse. It was about ownership of the method. If your face is the key, who owns the lock?
Apple hasn't commented publicly on the case, but litigation like this is a reminder. Even if you build the tech from scratch, someone might still claim they got there first on paper.
Intangiblia, the podcast of intangible law, plain talk about intellectual property.
You thought animated emojis were just cute? Well, according to face-to-face biometrics, they are patent-worthy, and Apple crossed the line.
In 2022, Face-to-Face Biometrics filed suit against Apple, claiming its emoji feature infringed on a patent for using facial expression data to animate a digital avatar.
Memoji, for the non-iPhone crowd, lets you control a cartoon version of yourself using your actual facial movements. Eyebrows, smiles, winks, the whole expressive package.
Face-to-Face said that's our invention. Their patent, granted in 2021, covered the use of facial recognition to dynamically control avatars in messaging systems.
Apple, of course, didn't just roll over. They challenged the claim and suggested the patent was overly broad and tried to monopolize a natural evolution of video communication.
Critics were quick to label Face-to-Face a patent troll. Why? They weren't making products or selling software. They just held the patent and filed a lawsuit.
It's the classic recipe. Get a patent, wait for someone successful to do something similar, sue, rinse and repeat.
Still, this case raises an interesting point. Where does technical invention stop and creative expression begin? Is tracking someone's wink to animate a digital koala really a novel process?
Whether face-to-face wins or not, the case shows how the patent system is being used, some say abused, to stake claims in the booming world of biometric entertainment.
Because in today's IP world, even your emoji isn't safe from litigation.
Next up, passive technologies, also known as the patent troll that never sleeps.
Pacid is a company with no products, no services, and no app. Just a fat stack of patents related to cryptography and biometric authentication. And they've been busy.
In 2024, they targeted Citibank and PNC Bank, two major US financial institutions. Why? Because their mobile apps allow users to log in using facial recognition and fingerprints.
According to Pacid, those login features infringed on 6 of its patents. The claims focused on methods for securely verifying users through biometric input tech that's now standard in every mobile banking app.
The kicker, Pacid didn't invent facial recognition or biometrics. They just acquired all their patents from a now defunct security company and decided to turn them into legal weapons.
And they didn't file just anywhere. They went straight to the Western District of Texas, a court famous for being, let's say, friendly to patent holders.
The case is still in motion, but Citibank and PNC are pushing back hard. They're arguing the patents are either too vague, invalid due to prior art, or simply unpatentable abstract ideas.
This isn't Pacid's first rodeo. In 2018, they sued Samsung over similar claims. Same playbook. Wait for the market to adopt a feature, then strike.
But here's the problem. Even if these patents don't hold up, the cost of defending against them is high, and that's the real leverage patent trolls rely on.
It also raises a deeper issue. Can a method of using your own face to access your own account be considered someone else's intellectual property?
Because if the answer is yes, we're all just renting our own identities. Liveness detection might sound like sci-fi, but it's actually a critical security layer in facial recognition, and in FaceTech v. Jumio, it became a full-blown legal brawl.
FaceTech is a US-based company that specializes in anti-spoofing tech, basically making sure the face in front of the camera isn't a photo, a video, or a 3D printed mask. Their flagship product, Zoom, uses 3D face mapping to verify that a real live human is present.
Jumio, on the other hand, is a major player in the AD verification game. They originally licensed FaceTech's liveness tech, but then switched providers, partnering with iProve instead.
That's when FaceTech flipped the switch. They accused Jumio of continuing to use their patented techniques even after the partnership ended and filed a patent infringement suit.
The case got messy fast. FaceTech even managed to disqualify Jumio's legal team, arguing conflict of interest because the same lawyers had once helped FaceTech file some of the very patents at issue.
Ouch. That's not just legal chess. That's queen takes queen energy.
At the heart of it, the patents covered methods for 3D liveness detection, like how the system responds to subtle user movements, lighting changes, and camera depth to confirm that the person on screen is real.
Jumio denied the claims, but the lawsuit highlighted just how valuable liveness detection has become. In a world of deepfakes, identity fraud, and synthetic media, having tech that can tell a live person from a fake one is pure gold.
And apparently that gold is worth fighting over. The case is still unfolding, but one thing is clear. Patents in this space aren't just about who invented what, they're about who gets to protect the gateway to digital identity.
When the whole economy runs on remote verification, the patent on "Are you real?" becomes a billion-dollar question.
And now the sequel to the live drama FaceTech VI Pro, because when it comes to anti-spoofing tech, apparently no one plays nice.
iProve, a UK-based company, built its brand on flash and video liveness detection. Basically, it uses timed light patterns and video frames to confirm that the face in front of the screen is live, not static or manipulated.
FaceTech said, hold up, we patented that vibe, literally. They claim that iProve's system infringed on FaceTech's proprietary methods for detecting live presence using device cameras and reactive light prompts.
They filed suit, pointing to multiple patents on their side of the Atlantic. And let's be clear, this wasn't about filters or novelty. These were security patents, the kind used in banking, border control, and national ID systems.
FaceTech's argument was that iProve's tech copied key aspects of their patented process and that it gave iProve an unfair competitive edge in high-stakes contracts.
iProve pushed back hard. They said their system was independently developed, fundamentally different in architecture, and, of course, non-infringing.
The legal fight spotlighted the fragmented but fiercely protected world of biometric IP. These aren't your average app patents. These are the digital equivalents of airport scanners. High value, highly regulated, and potentially high risk.
And remember, this isn't just a private sector spat. Both companies pitched to governments, banks, and healthcare systems. The winner of this IP showdown gets market access at a global scale.
The litigation is still ongoing, but whatever the outcome, it reinforces one thing. In biometric security, your secret sauce better be original because someone's always ready to take you to court over the recipe.
And in a world where liveness detection decides if your face is real, IP law is the new face filter.
Now that we've covered the courtroom drama, let's look at what lawmakers and regulators are doing to rein in facial recognition technology specifically. Because while the tech evolves fast, the laws, well, some are just catching up.
Let's start in the US, where biometric laws vary wildly depending on the state, and that matters a lot when faces are involved.
First up, the one and only BIPA Illinois Biometric Information Privacy Act, passed in 2008. It requires written informed consent before collecting any biometric data, including face geometry, and it gives individuals the right to sue. That's why Illinois is the home of blockbuster Faceprint lawsuits.
Then there's Texas, which passed its own Biometric Identifier Act in 2009. It requires consent but only allows enforcement by the Attorney General. No private lawsuits here.
Washington State followed in 2017 with a similar law. It requires notice and a clear purpose for collecting biometrics, but again, no private right of action.
In California, we've got the CCPA and CPRA. Together, they define biometric data as sensitive personal information. Users have the right to delete it and restrict its use, but lawsuits are only possible in cases of data breaches.
And don't forget the FTC. In 2023, it issued a policy statement warning that using facial recognition tech without transparency, data security, and consent could be considered deceptive or unfair under federal consumer law.
Beyond state lines, some cities have taken things even further. Portland, San Francisco, and Boston have banned the use of facial recognition tech by government agencies, including the police. These local bans signal growing discomfort with surveillance in public spaces.
Crossing the Atlantic, the GDPR, Europe's privacy powerhouse, has strict rules on biometrics. Facial data used for identification is classified as special category data, meaning it's off limits unless you've got explicit consent or a very strong legal reason.
That's why Clearview AI was banned or fined in nearly every EU country. Regulators said scraping people's faces from social media was a no-go under GDPR.
And the EU AI Act, expected to land in 2025, takes it further. It proposes a ban on real-time facial recognition in public spaces, unless used for very narrow law enforcement purposes. The idea? Stop biometric surveillance before it becomes the norm.
Post-Brexit, the UK kept the GDPR framework. Under the UK GDPR and the Data Protection Act of 2018, facial recognition data is still highly regulated.
After the Bridges v. South Wales police ruling, the UK courts made it clear even the police can't roll out live facial recognition without clear legal safeguards, bias audits, and accountability.
However, China, in 2021, it passed the Personal Information Protection Law, PIPL. It requires separate, specific consent for collecting sensitive personal information, including face data.
The twist? While the government uses facial recognition widely, private companies are now under serious restrictions. Courts have already ruled against businesses using face scans without necessity or alternatives. Finally, India passed its Digital Personal Data Protection Act in 2023. It classifies biometric data, including face prints, as sensitive and requires clear consent for processing.
This builds on the Padaswamy case, where the Supreme Court ruled that privacy is a fundamental right. It pushed the country to rethink how biometric data should be used, especially beyond state-run ID systems.
So, Denmark is making headlines. They've just proposed a law that will give citizens copyright-style rights over their own face, voice, and body. In other words, if someone makes a realistic AI deepfake of you without your consent, you'd have the legal power to stop it and even claim damages.
Finally, a law that says, hey, your face isn't public domain. They're basically treating your likeness like an original creative work, except the creator is nature, or maybe your parents.
The positive side, it could be a powerful tool against non-consensual deepfakes, image-based abuse, and unauthorized AI replicas of artists. It also sends a signal to tech companies: get consent first or face consequences.
And on the flip side, copyright law is tricky. If you start applying it to something as constant as your own face, you raise questions about free expression, parody, and even journalism. Will memes be at risk? What about satire or historical reenactments?
Denmark says exceptions for parody and satire will stay in place, but enforcement will be key. And this isn't just a Danish issue. They're already pushing for EU-wide adoption.
Which means if this spreads, we could be looking at a whole new category of rights in Europe, likeness, copyright. The big question is, will it protect people better, or will it just give lawyers more billable hours?
So while there's no one-size-fits-all approach, the global trend is clear. Facial recognition can't operate in the shadows anymore.
From consent forms to court rulings, your face is finally getting the legal respect it deserves.
Let's wrap up with 5 things we're walking away with. And they're not all lawsuits and legalese.
Exactly. This episode was a Faceprint fiesta, but there's good news too.
1, people are paying attention. From Illinois to India, citizens, courts, and regulators are asking smart questions about how facial recognition is used and making changes.
2, laws are getting better, whether it's BIPA, GDPR, or new AI acts. We're seeing a shift toward more clarity, stronger consent requirements, and real consequences for misuse.
3, tech companies are adapting. Settlements, policy updates, and design changes show that platforms are starting to take biometric responsibility seriously.
4, innovation can be ethical. Deepfake proofing, liveness detection, and privacy by design systems prove that protecting rights and building cool tech aren't mutually exclusive.
5, your face matters. Literally and legally, and more than ever, you have the right to say how it's used.
We hope today's tour of biometric brilliance left you feeling a little more empowered and maybe double-checking your app permissions.
Your face isn't just data, it's identity, creativity, security, and now protected by growing legal frameworks around the world.
If you liked this episode, share it with a friend who's ever used a selfie filter or unlocked their phone with a glance. So basically everyone.
Thanks for listening to Intangible. Stay curious, stay protected, and yes, smile is your right.
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.